Well, good afternoon, everyone. Hopefully people can hear me. If some of my team members can tell me they can hear me, that would be good.
I can hear you. Yep, we can hear you.
It's always encouraging. So, welcome to the Walker Morris session, where we're going to be looking at out with the old and in with the new. Well, we thought it was new. It's now second-hand because our famous Chancellor has just been announcing things. But it doesn't matter because we're going to deal with that as well as best we can. In terms of today, we're going to be looking at the essentially the exiting of the job retention scheme, the furlough scheme, the bringing in of the job support scheme, as best we know, given that the information was a little bit rough around the edges, shall we say, beforehand. Then we're going to deal with some issues in relation to the bonus arrangements the government are putting in to encourage, frankly, people not to be made redundant. And then we're going to try and look at some of the issues relating to essentially COVID and sickness and those sort of things. And the way we're going to do it is not in a sort of lecture style. We're going to do it with the four of us, my colleagues, Suzanne Treen. Suzanne can wave. There we go. Kendall Shepherd, different-handed, and Anna. Anna's very important because she's driving the system today, so we need her to be fully concentrating. We're going to divide things up, but also the way we're going to do it, we're not going to do it as a lecture. We're going to try, what we've done, the four of us, is use our experience from dealing with clients over the last few months, what questions are coming up, so that we have tried to anticipate what questions that you in the audience would also be asking. And that's how we're going to try and do it. Also, what we're going to do, hopefully you can see on your screen there's a Q&A function. We're all getting used to these facilities now. If you have a particular question as you go along, type it in, and then we will seek to address that as we go along as well. In terms of housekeeping, we're here till 1:30, so we will make sure we finish by then. Obviously, if there's questions which we haven't been able to get through, we will try to make sure we get back to you on those as well. Okay, so just a few introductory comments in relation to so the exiting of the furlough scheme. Everyone tuning in today will know about the furlough. They'll know there's only about 9 days left. If you haven't started telling people to come back, you haven't got much time left. I think one of the questions that we've been seeing is to do with how to deal with it practically. These people may have been away for 6 months. I think the common theme we're finding with clients is recognizing that people will be a bit nervous. Huge amounts have changed operationally using these sort of webinars, different functionality. People will have questions about where they're going to be working. We've seen a huge number of flexible working requests. And again, unsurprisingly, whilst the law hasn't changed, we do see people's approach to dealing with them have changed. We've done a piece on that. It's on our website, and some people have said it's helpful. Don't underestimate the fact that people will feel a little nervous. So do try to almost treat it as a sort of return to work process. Obviously, they haven't been ill necessarily, but do try to allow them some time to get back into the work systems. I think the final point I would make is we've all seen lots and lots of articles about furlough fraud. I'm not suggesting anyone on this call has committed that, but HMRC will undoubtedly be banging on people's doors. So just as you breathe a sigh of relief that the furlough system is coming to an end, keep your records. I think the mindset should be as if you're in a tribunal preparing for that. If you had to justify why Fred was placed on furlough, you just got it there. It's in your spreadsheet. Here are the documents, and here is how we told Fred not to do any work, etc., etc. Obviously drifting into the flexible furlough scheme, etc. So do keep those records. I think that's all we want to say about the furlough scheme, because it's, as we all know, it's coming to an end. So I'm going to hand over to Suzanne to give a few introductory comments in relation to the job support scheme.
Thanks, Andrew. So I've got the joyful job of explaining what we thought was the job support scheme, but obviously Rishi Sunak has just announced quite large changes to the scheme. So I think the best way to approach this really is to talk you through what we know so far in terms of the principle as the scheme as it was, and then give you a bit of oversight in terms of what we've gleaned from the announcement today. And obviously, as Andrew said, we'll provide updates accordingly once we have a bit more meat on the bones. I suspect it will be in the same way, governed by the same principles. It's just that it seems that the figures have changed and the balances of what's being paid has changed. So as you know, the original scheme was announced on the 24th of September, and that was aimed at protecting viable jobs. And at that point, cast your minds back to September, it seemed that the economy was opening up a little more, and the aim was to not support people who are in roles that are inevitably effectively redundant, but effectively to try and support businesses that have a demand, but it's lower due to winter and the impact of COVID. And the key was very much about viable jobs. However, as the landscape changed on the 9th of October, the government then announced an extension to the scheme to provide support for businesses whose premises had been legally required to close. And a lot of general points apply to both. Now, as I understand it, albeit it's fairly hot off the press, I think the revisions to the job support scheme relate solely to what we'd call the short-time working scheme. And I think that the position is still the same in terms of the business closure scheme. But obviously, once we have a bit more information, we can update you on that. So I think it's probably helpful to just give you a bit of an overview of what the eligibility, etc. rules were for under the job support scheme as announced, and from the information that we do have. So in terms of who is eligible for the sort of short-time working element, and indeed all schemes, it's all employers with a UK bank account and UK PAYE schemes. And neither the employer nor the employee needs to have previously used the coronavirus job retention scheme. Large employers will have to meet a financial assessment test, so the scheme is only available to those whose turnover is lower now than before because they're experiencing difficulties from COVID. And I think, as I understand it, the same will apply for the new scheme, so large businesses will need to show an impact on revenues. We'll come on to talk about who is a small and medium employer shortly. The government has stated that it's their expectation that large employers using the job support scheme wouldn't be making capital distributions such as dividend payments or share buybacks when they're accessing the grant. And they have said that further guidance will be set out. And as you know, we haven't actually had the full-blown guidance for the job support scheme. I suspect we won't be getting that for a little bit longer now, because obviously there's going to be revisions made in light of the Chancellor's announcement this morning or this afternoon. So in terms of the employees must be on the employer's PAYE payroll on or before the 23rd of September, and we assume that that will probably still stand. So what this will mean is that the real-time information submission notifying payment to the employee must have been made on or before the 23rd of September. Now, this is the bit that will undoubtedly now be changing. So under the scheme as announced originally, employees must have worked at least 33% of their usual hours, and that would be reviewed after 3 months. And then what would have happened under the job support scheme is that for the time worked, the employees would be paid their normal contracted wage. And for every hour not worked by the employee, both the government and the employer would pay a third each of the usual hourly wage. And that was capped at $697.92 a month. So that would have had the effect of, assuming that the employee only worked 33% of the time, the employer would pay 55% of the employee's normal wages and the government would have paid 22%. Under the new scheme, it seems that instead of paying 55%, the employer would pay 20% of the usual hours worked, so the normal hours worked, and 5% of hours not worked, and then the government will pay 62% of wages not worked, up to a maximum of £1,541.75. So it goes from the government contribution being, in the most generous cases, from about 22% to just under half. So that's hot off the press. Obviously, I suspect that there will be more sliding scales about how that will work in practice, being published probably via a fact sheet later today. But I think the principles, as I say, will be the same, so that employees will be able to cycle on and off the scheme and don't have to be working the same pattern each month, but each short-time working arrangement must cover a minimum period of 7 days. I think the new scheme really is open to all small businesses and larger businesses that can show they've had an impact. So it's not necessarily, as I understand it, tier specific. And we assume that the principles will be the same in terms of Class 1 employer national insurance contributions and pension contributions, i.e. they're not covered and will remain payable by the employer. And again, I think the key point here, as Andrew's mentioned, there's a lot of concern, or there has been a lot of concern, over the level of fraud that's been perpetrated under the coronavirus job retention scheme. So HMRC will be checking claims, and they do reserve the right to withhold payment or ask for payment to be paid back if it's fraudulent or based on incorrect information. And the key here as well, which we think will be the same, will that grants can only be used as reimbursement for wage costs actually incurred. So I think that's a good summary there. And then I think Andrew's going to talk me through some questions.
Well, I think first of all, I'd say, given that you had about 10 minutes to update your talk, you did very well and a lot better than Boris Johnson would have done, which is a low bar, perhaps. But
thanks, Andrew.
Yeah, I think it was pretty impressive. I suppose, again, the questions which, if I was in the client's position, I would be asking is like, well, okay, when can you start making these claims?
Yeah, so I guess rather than saying this at the beginning of every question, I guess we'll say let's wait and see. Yeah. But ultimately, based on the terms of the current fact sheet, we understand the scheme will be open from the 1st of November until the end of April. Now, the key point here, I think what they were trying to ram home to everybody, is that you would be paying the individuals, the employees, first. So you would have to make your claim online through Gov.uk, and that opens in December, and then you would be reimbursed for the payments. So you're going to have to wait at least a month until pay is reimbursed, and that will be at some point in December. Okay. Put simply, employers won't be able to defer payments under the scheme. You will remember that some employers had to defer payments under the furlough scheme. You won't be able to do that, we don't think. Okay.
And I think to an extent you've covered some of this in the preamble about what's going to be covered by the grant.
Yeah, so I've talked about Class 1 employers and ICs and pension contributions. They're payable by the employer, so they're not covered. Usual wages will be covered, and we're told that that will be a similar methodology as the coronavirus job retention scheme, so there'll be more information coming on that. But employees who've been previously furloughed, again, you won't be able to use their furloughed wages, we don't think. It will be to calculate it from their usual wages, and that's in line with legislation that's coming around redundancy, etc., over the summer.
Okay. And another type of question we've been seeing is the sort of the horrid interrelation between furlough, job support, sickness, holiday. You know, how does that lot fit together? Can people sort of use their sickness and their holidays as part of the scheme?
So I think if the new scheme's emphasis, so the original job support scheme's emphasis was around viable jobs and short-time working. So if you go by the principle of the scheme as set out, employees must be at work and working at least 33% of their hours to qualify for the scheme. So there's an argument to say, well, why should the government meet holiday pay costs, particularly if it accrued before the scheme came into force? However, you will remember that the coronavirus job retention scheme, employees were allowed to take holiday when they were on furlough. I would say that they may go for a hybrid. I suspect what they will do is, if you're sick and you have the benefit of SSP, then you'd be paid that, and they may want employers to meet the costs of holiday, because obviously a lot of employees will have banked holiday over this period anyway.
Yeah, okay. So again, there are knotty issues to unravel.
Yeah.
I think, as is always the way with holiday and sickness. You mentioned during your sort of introduction, there is this concept of a large employer and sort of slightly different rules applying. Begs the question, what on earth is large?
Yeah, so I think the guidance will probably define SMEs in the same way as previous COVID-19 related legislation. So, for example, in some of the SSP regs, they said an SME would be an employer with 250 employees or fewer. And it's not clear if they'll apply the financial assessment to companies within a corporate group or an individual company basis. I know we've got clients who are listening who may well be in a large group that's profitable but have an individual legal entity that isn't.
Mm-hmm.
I think given the widespread feeling that the furlough scheme was subject to abuse and fraud, I suspect that in order to claim, employers will need to meet a range of tests and show that they're not part of a group that's profitable and therefore shouldn't be claiming.
And those are those tests we just don't have yet. That's right.
Yeah, that's correct. Yeah.
Okay, that's helpful. Again, other questions that we've sort of gathered from clients over the weeks is: could an employee work more than their notional 1/3 of their hours?
I mean, under the job support scheme, yes, as was. The idea is that you just have to work a minimum of the 33%. Mm-hmm. And then it would be a sliding scale in terms of the reduction. So okay. I anticipate that would be the same under the new scheme.
Okay. So we're going to have to get our calculators out as to how it all works.
Yeah,
and definitely. Another calculation type question is what we were seeing with furlough and still seeing is some employers chose to top up, because obviously with the furlough scheme you had a certain cap and then 80% and all that sort of concept. Is it available to the employer to top up here?
So interestingly, the government fact sheet says that their expectation is that employers can't top up the employee's wages above the 2/3 contribution to hours not worked at their own expense. It's not clear if this means we don't think you'll be able to afford it and therefore we don't expect you to do it, or it's prohibited. And therefore that means that employers who want the grant but could afford to pay employees don't then dip into the grant.
Okay. So again, we're waiting for more clarity on that point, I think.
Yeah.
Okay, so the employer is now saying to me, right, I've gone through these various questions. I think I can do it. I think I'm going to start filling in the forms. How do I actually process this and communicate and deliver the rules and the working practices to my staff?
So I think that's a good question. For those employers who've used furlough before, you'll remember that we kind of had advised that we use a process similar to a sort of redundancy process. So if you're in a situation whereby you had 10 employees and you needed to put 5 on the scheme, you'll obviously be able to have some sort of rationale for justifying that in the similar way that you would for redundancy, and perhaps have a chat with those employees and a talk about why. For employers who have, they need to put a whole section of their business on it, that way it will be less consultative, possibly, depending on whether you've got unions, etc. And that might just simply involve writing to employees and setting out the proposals to reduce the hours and the reasons why. And obviously great care needs to be taken, because what you don't want to be doing is saying accept this or we're going to dismiss, certainly if it's more than 20, because then you're triggering the collective consultation obligations, i.e. if you're proposing to dismiss 20 or more employees in a period of 90 days or less, then you have to carry out collective consultation, which means electing reps, etc. The approach that we've generally taken is to have a letter, write to people, explain the reasons, explain what the alternatives might be. So, for example, we'd have to look at layoff or redundancy, etc. And I think quite importantly, under the terms of the scheme, the fact sheet sets out that employers need to agree new short-time working arrangements, make any changes to the employment contract by agreement, and notify the employee in writing. I mean, it should be in writing anyway to avoid claims for unlawful deductions, breach of contract, and so it's really clear. So, and I also think it's important to know that HMRC might ask for that document. So really, I think one final point to add is that the government has said it's its intention to inform the employees the full details of the claim made by the employer, presumably so your employees can dob you in if there's any abuse of the scheme.
Yeah. Is there any talk of, obviously with the furlough scheme, they had a sort of whistleblowing hotline type thing? Is there talk of that?
Yeah, so on the second fact sheet for the closure of premises, that one says that it will name employers who are claiming for it, and I think they've talked about potentially a hotline. I think what they're saying in both schemes is we're going to be really transparent with employees, with the implication being we're going to dob you in if you're abusing the scheme.
So you can dob in your neighbours at home for having too many people in the garden and your work colleagues?
Yeah, it's brilliant.
Yeah, that's all good. And just on that, bear in mind there is an increase in people asking for interim relief for whistleblowing claims in the tribunal, and that can get very, very expensive because people end up having to pay their wages until the tribunal is sorted out, which could be years. So just be careful if people do blow the whistle. Yeah. Okay, so thank you for that. And I think what I'm taking from that is don't forget the fact that even if you follow the scheme, the basic underlying law is still there. Contract, consultation, discrimination, whistleblowing, basic.
Yeah.
What happens, you look at all the rules and if the employer say you're not eligible, what can an employer do then?
I think it's potentially back to the drawing board. What you'll have to do is look and cost up whether or not the new meet the requirements or help your business. If they don't, you might be in a position where you're looking at making further redundancies or other options such as layoff, short-time working if you've got a contractual right to do so, or just simply agreeing temporary changes to terms and conditions as a whole with your workforce, so reduced hours and reduced pay. One issue, I suppose, is that some businesses have really key employees who they want to retain and they don't want to cut their pay because they don't want them to go and work for a competitor. So some issues you could look at, if you're a group, you could try and second them elsewhere and keep them happy in doing that.
And is it right that there is a sort of different set of rules for closed businesses?
Yeah, so the closed business rules, and again, as I understand it, the new scheme doesn't affect this, but again, we've had about not very long to have a look at it. Assuming that's not affected by the amendments that she made, then effectively that scheme was to cover businesses that were legally required to close, including those that restricted delivery or collection. And under that scheme, basically the key difference is that the employee is unable to work and the employer must have ceased work for 7 consecutive days. And sorry, go on.
No, I was going to say, so it's another thing to look at the right time. If that's applicable to people, they need to blow the dust off that schedule.
Yeah, and the money that they pay is different. So as it was up to 67% of wages, so capped at $2,100 a month. And the employer isn't required to share wage support with the government for unworked hours. There was some argument about that being up to 80%, but I think that's only if you're on a low income and you can claim universal credit.
Okay. You can go and have a rest for a few minutes. So thank you for that, Suzanne. And again, people sending questions in, what we can try and do is collate them, and then we're leaving a bit of time at the end to try to come back to Suzanne's bit as well. I think that leads neatly on to the concept of the job retention bonus scheme, and we've asked Kendall to say a few introductory words on that, and then again, all those questions which I've got in my head, Kendall can try and explain.
Yeah, thank you for that, Andrew. So I'm speaking about the job retention bonus scheme. This is a new scheme provided by the government to offer additional support to those employers affected by the coronavirus pandemic. So the new scheme has been designed to encourage employers to retain as many employees as possible that have been on furlough. So the key terms of the scheme are that the government will pay a one-off taxable bonus to eligible employers for each eligible employee that it furloughed and kept continually employed from when they were last claimed for on the furlough scheme until the end of January 2021. It's a bonus that's set at £1,000 for each eligible employee, but it is worth noting that although you're claiming for an eligible employee, the bonus itself is actually for the employer. So the money doesn't need to be paid to the employee, and the employer can do with it as it wishes. So if you wanted to put it towards employees' wages, you can do. Likewise, if you want to keep it for the business, that is up to you. The bonus cannot be claimed until the 15th of February 2021, and there's only a 6-week window in which you can claim. So you need to sort of have a think now of who these employees might be, and remember to claim in the 6-week window.
Okay, that sounds all very good. So I suppose the obvious question is, who can claim these types of bonuses?
Yes, so employers who furloughed employees and made an eligible claim for them on the Coronavirus Job Retention Scheme can claim the bonus.
Yeah.
However, there's a few caveats. So if you didn't make a claim for the employee through the Coronavirus Job Retention Scheme, then you can't claim for them. If you've repaid all of the grant money that you claimed under the Coronavirus Job Retention Scheme, again, you can't claim for them. And that's regardless of the reason why you repaid the money. So if you was repaying the monies in good faith, thinking, oh, we're back to being in a good position, we'll repay the monies, that's all well and good, but unfortunately you now can't claim for the bonus.
Right.
Again, similarly, if you've had to repay it because you've been a bit naughty or claimed incorrectly, you can't claim it, and they're just tarnishing everyone with the same brush, really.
Mm-hmm.
If eligible employees are serving notice, so whether that's contractual notice, statutory, or a notice of retirement, on the 31st of January 2021, can't claim the bonus for those employees. And finally, you must have paid the employee at least the minimum income threshold in the relevant tax periods between November and January, at the end of January, to be able to claim. So this means that the employee must earn at least £1,560 gross throughout those 3 tax periods, and it is only the information on HMRC's real-time information records that will be counted. The HMRC have pulled together some useful worked examples on the website, which are worthwhile to take a look at, and we can share the link to that afterwards. Yeah. But I will work through one example now, just while we're on this.
That'd be good.
So, for example, let's say Bob. So Bob usually earns £1,800 a month, but he was off sick for a few weeks, receiving statutory sick pay, and that extended to the whole of December. So his pay in the relevant tax periods was November to December, and they run from the 6th to the 5th of the month. So from November to December, he was paid £1,500. For December to January, he was paid £385 because he was on statutory sick pay. And then for the start of January to the end, he received £1,700. As statutory sick pay counts as taxable earnings, Bob received taxable earnings in each tax period, so that's helpful. So his total taxable pay was £3,585. So this exceeds the maximum income threshold, the minimum income threshold, of £1,560. So his employer can claim the bonus for him. However, if, let's say, Bob had been on statutory sick pay for all 3 tax periods, although he would have received taxable earnings in all of the tax periods, his taxable pay would only have been £1,155, so it would have been less than the minimum income threshold. So in that instance, the employer wouldn't be able to claim.
Okay.
So you just need to be careful in terms of what elements could reduce.
Okay, so that's, I think, yes, and look out, if people who are tuned in, look out for the links and bits and bobs we can send around. I think that seeing a worked example is quite helpful, isn't it? So I suppose the obvious, difficult question for you is, at 11 o'clock this morning, what would your answer have been to, does the job support scheme change anything?
So as far as I've seen, the changes that Rishi has announced don't change the bonus. Okay. So if you are using the job support scheme, you can still claim the job retention bonus.
Okay.
So as long as the employees were placed on furlough under the coronavirus job retention scheme, and you made a claim for them under that scheme, and they continue to meet the eligibility criteria through the job retention bonus scheme that I've explained, then you should be fine. To be clear, though, there is no need to use the job support scheme to be eligible for the job retention bonus.
Okay.
Similarly, if you furloughed employees in March and you've been able to bring them back and they've been back at work for quite a while now, you can still claim for those employees as long as they meet the eligibility criteria. So essentially, the job retention bonus is not just for recently returning or soon to be returning employees. It's for all employees that were furloughed.
Okay, that's all good. Makes you think, doesn't it? If someone could write in with a limerick which includes the words coronavirus job retention scheme, job support scheme and job retention bonus, there'll be a prize, because it'd be quite a mouthful to get all that together. So, okay, similar question I asked to Suzanne really is, okay, I've got all that. I think I'm eligible, etc., etc., etc. How do I process this, and when do I process my application for the job retention bonus?
Yeah, so it's intended so far that, again, it'll be an online portal service.
Okay.
That is going to be set up for you to submit the claims electronically. We don't really have much other information about it other than that at the minute, but the government have promised that it intends to update its guidance on how to claim by the end of January 2021. And it's worth remembering that although January 31st is sort of the cut-off date for people still to be employed and earning, you can't claim the bonus until the 15th of February at the earliest. So hopefully the guidance will be brought about at the end of January, and then you'll have 2 weeks or so to get your head around it and make the claim. And as I said, it's only a 6-week window to make the claim, so try and get your ducks in order.
So other than the timing problems, are you, in your experience, what would you be advising clients about the potential pitfalls and the potential problems?
Yeah, so the current problems that we foresee are that HMRC are still checking the claims that were made on the coronavirus job retention scheme. So you can still make a claim for the bonus, even if HMRC are still checking your records. However, payments are likely to be delayed until HMRC have completed their checks. If you made an incorrect claim on the coronavirus job retention scheme, then you won't be paid the bonus. As I mentioned before in the worked example, statutory leave and also pension deductions can reduce the employee's taxable pay below the minimum threshold. So some leave could make them ineligible. And also, I guess the thing to highlight is that if an employee resigns before the 31st of January, then employers won't be able to make a claim for that employee. So I guess try not to annoy your employees on the run-up, just in case they want to be a little bit vindictive. And
Yeah. And I think don't annoy your payroll staff, because they're going to have a bit of a headache working all this out. So be nice to your payroll people. Okay, I think that's enough on that. So that's another interesting dynamic. I mean, hopefully, it's a good news thing. Ultimately the government are offering money, but there are hoops to jump through. Okay, and again, as and when we get more guidance, we will ping that round. So Anna, this is the third section or fourth section, I suppose. It more to do with we're not going to use the word job retention or furlough or anything, but more COVID. And I suppose even more relevantly now, it is, what are we meant to do if someone at work gets COVID?
This is strangely still a big question, even though obviously COVID's been around with us for quite some time now. As people start going back to work, the furlough scheme comes to an end, ignoring local lockdowns, obviously. Cases are on the rise again as we come into winter, so it's quite important to know what to do. Unfortunately, I don't have a kind of straightforward one-size-fits-all answer to that question, but from a general perspective, what employers have a duty to do is to ensure that they're protecting the health, safety and welfare of their employees at work so far as they reasonably can. And that also extends to ensuring that non-employees are not exposed to risks to their health and safety while they're in that workplace. So sort of visitors, customers, contractors, etc. So what businesses should be doing in order to demonstrate that they are doing everything that is reasonably practicable is following the government guidance. So what is actually appropriate in terms of proper practical steps will largely depend on what sector you're in. And there are now 14 different iterations of the COVID secure guidelines for each different sector that's allowed to be open at the moment. It is worth keeping an eye on those because they are updated from time to time. But the key thing to ensure is that you've got your COVID-specific risk assessment done and you do have a plan in place in case cases do occur. I think one thing that is particularly worth noting is that workplaces do not necessarily have to close if a positive case occurs, although obviously in certain situations that will probably be the best course of action. For example, if you can't continue to operate safely because of absences, or if that's the best way to stop a full-on breakout. Another thing that I think will probably appear in most people's plans is a deep clean routine. And you should certainly be reassessing your risk assessment if a case does occur to check that everything is still COVID secure and in keeping with the guidelines. Helpfully, some of the guidance does include some quite detailed instructions on how to perform a deep clean if somebody has a suspected or a confirmed case and has now left the workplace. One final thing that should appear in most plans as well is that if there is more than one suspected case or confirmed case in the workplace, you should be reporting to Public Health England because they'll class that as a suspected breakout.
Okay, that's sobering, but it's sort of encouraging because that rings bells as to what we're an employer as well. So that's what we've been doing. Just as an aside, to illustrate the fact that there are many grey areas in this. We actually, as a group, debated. Our office is open. We debated should we do it at work or from home. For better or worse, we've done it from home. Different people will have different views on that. Okay, so that's interesting. So again, there's a whole series of tests and interlocking things, touching on the health and safety, common sense, decency, those sort of things. So where have we got to with, again, another one of the questions I keep getting is, what about pay? So obviously we've got the usual concept of you've got to pay people, what the contract says. Then various other variables within all this, whether it's COVID or whatever. So what are the key points about paying people in these scenarios?
It's a complicated question, I have to say.
Yes.
But I think two of the key things to remember that were facets before all this kicked off is that if your employee is unwell and unfit to work, whether with coronavirus or suspected coronavirus, they'll be entitled to their usual sick leave and pay entitlements, including SSP and any contractual entitlements, just in the same way that they would be if they had flu or a stomach bug or anything like that. So that's your starting point. Another thing to note that is still the same as well is if the employee is well enough and they can effectively do their job from home, then they can continue to do so, and you can continue to pay them as normal.
Okay. Okay, but then the next layer of questions you get, whether it's at work or relatives calling you up, is what about if I've got to self-isolate? How does that change things?
So this is really where it does get a little bit more complicated. As well as if you're sick or otherwise showing symptoms, the statutory sick pay regulations have been extended to cover a whole host of other circumstances where SSP will be payable. In quite a lot of them, the employee won't actually be unwell, but they're still deemed incapacitated for this purpose.
Okay.
I'll take you through them as succinctly as I can. There's a few different ones. So if the employee is living with someone or in an extended or linked household with someone who themselves is having to isolate because they've got symptoms, your employee also has to isolate and they'll be entitled to statutory sick pay. To add an extra layer onto that, if the employee themselves then develop symptoms from that, they go back to day one of their isolation and they're entitled to SSP for that full period. If you get a notification, your employee gets a notification from the NHS Test and Trace app to say that they've come into contact with somebody who had COVID at the time, again, they need to isolate and they'll be entitled to SSP.
Yep.
Obviously, if the employee tests positive for COVID, regardless of whether they have any symptoms or not, they'll need to be isolating, and the same if they live with anybody who tests positive. You guessed it, self-isolate SSP. There's also a relatively new one that's been added, which is your employee may not be on sick leave, but they may have a scheduled procedure at a hospital for surgery or something similar. And they might be asked by their doctor to isolate for 14 days, to protect the health service and cut down on outbreaks. And in that case, again, they'll be entitled, or they must self-isolate and they'll be entitled to SSP. It does also technically come into play when people are shielding, but as we're probably aware, that's paused for now. But if cases do keep on rising over the winter, then that might well come back into play again.
Always fun talking to you, Anna. All these happy things. But again, you did a better job than Boris explaining that. So, okay. So again, I think the take-home message there is it's layer upon layer upon layer of stuff to try and unpack. Are you finding, or maybe I open up to all three of you, are people finding that people want to pay full pay if people have got sort of COVID-y type things?
I think it's a mixture, really. We have some clients who basically said for a certain period at the beginning of the pandemic, they would honour full pay to everybody for a period of, a month and a half, and then they would review it. Other clients have said, look, we'll pay on a discretionary basis and we'll review again if you're off for the period of quarantine or self-isolation, not necessarily quarantine actually, but self-isolation. So I think a lot of employers see the value of keeping, infected employees out of the workplace, but equally you're looking at, depending on how big your business is, a great cost, because obviously if track and trace was working more promptly, then you wouldn't have people coming in who are infected and then infecting others, and then that being a knock-on effect. So I think it's fair to say that a lot of people have been doing it, but on a discretionary, limited basis.
Okay.
There's certainly merits to it in some cases. I would say the government has introduced some regulations to try and cut down on people who feel aggrieved because they're not unwell but they have to isolate, and they stand to lose out on pay, particularly if they can't work from home. So the government has introduced some regulations which aim to try and keep people from coming to work even when they're otherwise well.
And I suppose that leads on to the next thought of mine. We hear about quarantining and all those sort of things. Probably for you, Anna, where are we up to on the concept of quarantining?
It's a good question. It is slightly distinct from self-isolating, and just to be clear, when we're talking about it, we mean that the employee has to self-isolate specifically because they've returned to the UK from having been to a country that's not on the government's exempt list, which, as I'm sure we're all used to now, just changes at the drop of a hat. So the basics are the same. If they come back and they're unwell, sick pay is normal. If they come back and they can work from home, you don't need to lose that productivity and they can carry on, and you can continue paying them as normal. Where it differs is if the employee is otherwise fit for work and is unable to work from home, they're not technically legally entitled to be paid for that time because they're not actually ready and available to work. So actually the default here is that the 14-day quarantine period is unpaid leave. It's then up to employers on a case-by-case basis to decide whether it's appropriate to let the employee take some further leave from their annual leave entitlement, whether you just leave it as unpaid leave or whether you do a combination of the two. I think I would just caveat that with saying if they've had to travel for work, then you might struggle a little bit more to say, sorry, we're not going to pay you for 2 weeks when you come back. There'd be a greater argument to say that the employee should be paid for that time.
And I suppose if you're getting it wrong, you're going to get a load of people banging in unlawful reduction claims.
Yeah, exactly.
Yeah.
Similarly, I'd say if the rules suddenly change while the person's away, maybe consider exercising your discretion in those kind of cases. Yeah. And perhaps just warn people if they're going away. You might not be entitled to any pay when you get back.
The only boring thing I would add to that is, and it's really sad, I've observed over the years that it's now more dangerous to exercise your discretion because you exercise it for Suzanne, but then Kendall says, why didn't you do it for me? You know, and I'm different because of, you know, any number of protected characteristics or this, that and the other. And then you need to justify it. So
yeah, it's definitely sensible to record your reasons for the decision. Make sure you're keeping everything documented and try to be consistent wherever you can. As the best advice.
It's sad. It does slow down sort of spontaneous kindness. Such is life. Okay, well, I think we've reached the end of things normal play, as it were. Let me have a look to see what questions we've got coming in. One for you, I think, Kendall, in the sense of, can you remind us what are the dates for the key dates to put in your diary in relation to these bonus stuff?
Yeah, of course. So the key dates, if people have got pens at the ready, so the first taxable period starts on the 6th of November. So that's the first one to keep a note of. So that's the first taxable period that you can claim for out of the 3, and then obviously the rest are consecutive. The next key date, I'd say, is the 31st of January. So to be, to claim for eligible employees, they must be employed by this date, and they mustn't be under any form of notice. The next date for when the scheme opens is the 15th of February. So that's the first date that the job retention bonus can be claimed. And the final date is the 31st of March. So this is the last date to make a claim. The scheme closes on this date, and any claims made after this won't be accepted.
Okay. Brilliant. And again, if people didn't manage to have a pen to hand, just drop us an email. We can ping you those dates. And actually, I've got another one here for you, Kendall. Someone's saying, I've got a number of employees who have transferred to our business under TUPE. How is that going to work out in relation to the job retention bonus? Am I still eligible?
Yeah, so you can still claim for the employees that have achieved transfer across to you, provided that they've transferred under TUPE, the PAYE business succession rules have applied to the transfer. Again, continuously employed since the last claim was made for them under the coronavirus job retention scheme. They meet the eligibility criteria, so just like anybody else. And you have made and submitted a claim for the employees under the coronavirus job retention scheme, then you should be able to make a claim for them under for the bonus scheme. However, you won't be able to make a claim for the bonus for any employees who transferred to you after the 31st of October when the furlough scheme ends.
Okay, so again, more dates, more weeds to get through. Okay, and then perhaps just the last question I've got to Suzanne really is, given that you've had about 7 minutes to think about it a little bit longer, are there any other tidbits you can of wisdom you can give in relation to the changes? Are there any limits or this, that and the other which have changed?
So I think the key point is today's announcement effectively reduces the amount of contribution required by the employer overall.
Okay.
So for it's down to 5% for hours not worked, and it seems to be that the minimum threshold, which was 33% of hours worked, has now been reduced to 20%, and then overall the government is increasing its contribution to a maximum of 1,541 and 75. So I think the take-home point here is employers pay less and the government pays more. And then the amount of hours that need to be worked has reduced, I believe, to about 20%.
And I suppose, again, the net effect of that, what I'm seeing is when clients are, the reality is, unsurprisingly, a lot of clients are starting redundancy processes. They were starting them in, summertime, springtime. But the more government schemes which are thrown up, which again, I think the aim is perfectly sensible, and it's designed to slow down redundancies. Sensible employees are throwing it back to the employer to say, how can you make me redundant if you've got access to this scheme? I think that the general advice, which is to an extent partly legal, partly common sense, partly decency, is pause if you're in the process of making redundancies now and you're about to pull the trigger, I think the common sense thing has got to be pause for at least 24 hours to think, okay, what is the scheme? Does it make a difference? Does it allow me as an employer to hold off making those redundancies? Now, I don't think it will ever prohibit you from making redundancies, but you don't want to be in front of a tribunal and the tribunal say, well, did you consider it? Did you consider all means of avoiding redundancies, etc., etc.? So I think, at the very least, it should be an instruction to tell people to pause, consider, consult, and if you still need to make redundancies, then sadly, so be it. Has anyone else got any, I suppose maybe just go around here before we wrap up. If you were to give one sentence of advice, to people, perhaps something you've heard from each other, and any sort of closing comments.
Well, just to add to the point you were just making, Andrew, and I mean, obviously we've flagged this already, but the purpose of the job support scheme is, what it says on the tin, is to try to support jobs. So it's very clear in the fact sheets that the employers who are seeking to make people redundant shouldn't be using that scheme. So if you start to use the scheme and you realise, hang on a minute, this isn't working or we're in trouble here, then you would have to take the employee off the scheme and not claim the grant. I think in terms of a sentence to add up is stay alert, in the sense that guidance is coming through thick and fast and things are changing, and we're by no means out of the woods yet. So I think unfortunately for practitioners of employment law, there's no rest for the wicked, and it is really important to try and keep up to date, because as this seminar has shown, things can change within a period of 15 minutes, and obviously we'll be here to try and help you work your way through it.
That's cool. Kendall or Anna, you words of wisdom?
I think mine would just be to make sure you're keeping your risk assessments up to date and communicating what's going on. So if you're making any changes, everyone knows. Because as you said at the beginning, it's a stressful time for everybody. And obviously things, as Suzanne's just said, things are changing. So keep an eye on the guidance, and we'll send around the appropriate links afterwards.
Okay, that's cool. Kendall?
Yeah, and just in terms of trying to calculate the earnings within the taxable period, just sort of keep an eye on what may potentially reduce them and mean that the bonus can't be claimed for the employees. And as I said before, the works examples on the HMRC's website are really useful. They do take quite a lot of clicking to get through to them, so we can forward on the link which will be easier for you to access.
Okay. Well, thank you, everyone who's tuned in. Thank you for Kendall, Anna, Suzanne, and for all the sort of back office staff who's put this together. There is a lot to think about. There is a lot to do, and there are a lot of challenges. As Suzanne says, stay alert and eat your vegetables. So have a good afternoon, and do contact us if you have any questions. Okay, have a good day. Bye.
Thank you.
Thank you.
Bye.